This
on
conference
SRBX.
will now be recorded.
So as we all know, basically the world's been turned on its head. And just as governments and business are trying to respond to the COVID-19 pandemic, so is SRBX. Just before we get started, we'd just like to inform you of a few things. Our advocacy team and our members from our legal committee, we've been responding to the governor's order for the stay-at-home order right when it was initiated. I think you all know that there was some confusion when the order was put into place as to whether or not construction was defined as an essential business and was exempt from the order. Because of that lack of clarity, SRBX, along with our industry partners, both at the local and the state level, we immediately responded, and we were in contact with the governor's office to urge that they clarify the governor's order and to exempt all construction from his order. We're pleased to say that the governor did in fact do that, and we're continuing to monitor the situation as it unfolds. There are some local jurisdictions that are putting out their own orders, and we're trying to encourage them not to be more restrictive than what the state allows so construction can continue along. I would remind you to use the SRBX website as a resource. You can go to www.srbx.org. At the top of the page, we have a link to our COVID-19 website, and we're posting information on a daily basis to help keep you up to date. As we do move forward with construction going forward, there's a few things that I would like to say. The governor's highest priority right now is to arrest the spread of coronavirus. Before that, we know that he is obviously very interested in residential and multifamily construction, as well as infrastructure construction around the state of California. Those do remain to be high priorities, and so the governor's clarification on the order that all construction was exempted, he wants us to continue to do the work that's important to the state, to our economy, and to our communities. One thing to be cognizant of is that the order was very specific. Construction can continue if we do observe the same guidelines for maintaining hand washing to avoid the spread of the coronavirus, as well as maintaining the social distancing. It's imperative for you companies that are working on work sites right now, continuing forward with your jobs, that you do everything that you can to be sure that your tradespeople on the job site, all your people, are observing that social distancing and the CDC guidelines for preventing the spread of the virus. If you go to the SRBX website on our coronavirus page, one of our member companies, XL Construction, provided a copy with their pandemic action plan. They've made that available to the construction industry to make sure that we can all continue to build safely and effectively. So I would encourage you to go to our website and download that information. With that, I'm going to throw it over to Damon Conklin, who is SRBX's Government Affairs Director, and he is going to kick off with our presentation. And while he's doing that, I'm going to queue up our PowerPoint. So please, I hope you find the information that's presented informative. And please, again, remember to mute your phones if you haven't yet already done so. Damon, take it away.
Thank you. Good morning. And as everybody knows, COVID-19 has changed the world as we know it. While learning that the construction industry is considered essential and now exempt from shelter-in-place orders, many are still experiencing heightened feelings of anxiety as we try to navigate through these uncertain times. To many of us, this seems to be more, appears to be more questions really than answers. So to really help lessen the impact on the construction industry, our members and their employees, it's at the foremost of our minds, and thus the impetus for this webinar. We assembled a panel of SRBX Legal Committee members to help kind of bridge this informational gap. Joining us this morning is a panel of seasoned legal experts from our legal committee to help us kind of work through and better understand what's happening at the federal and state level with regard to employment and contract law. After each of the panelists go through their presentations, we'll dedicate the remaining balance of the call towards questions and answers. To submit a question, email it to dconklin@srbx.org, Every other slide will have my email address there, so just take note of it through the presentation. And again, at your earliest convenience, just email those questions off to me. Our panel includes Carrie Bushman with Cook Brown, and Greg Raum and Neil Bowie with McInerney and Dillon. Perhaps each of you can briefly share with us your individual focus and expertise in respective fields. Carrie, can we start with you?
Sure. Good morning, everyone. So I'm a partner with a law firm here in Sacramento called Cook Brown, and we focus our practice almost exclusively on representing companies and management in labor and employment issues. And I do a lot of work. I'm going to say probably 85+% of my work is working with contractors and other construction-related entities. So what I'll be talking about here today during my portion is really sort of focusing on the issues that have come up that I've noticed with my clients over the last week or so.
Great. Greg, can you tell us a little bit about what you do and your area of expertise?
Yeah, I'm an attorney with McInerney and Dillon. We're a construction law firm, have been around for over 60 years, pretty much exclusively construction litigation, some real estate, and we have a small business formation practice. I've been getting a lot of questions about what to do in terms of delay and a lot of employment questions, so I'm glad that Carrie can address some of that. And Neil, a partner at our firm, is here as well. Neil, are you there?
Yeah. Good morning, everybody. My name is Neil Bowie. I'm also a construction lawyer, shareholder at McInerney and Dillon. Like Greg said, we're a construction law firm, boutique construction law firm covering all gambits. My particular practice involves general contractors and developers, mostly these days. And so I've been asked to sort of field some questions and that we've been hearing from our clients, and maybe give a little bit of guidance in this quickly changing world with the COVID-19.
Great, thanks, Neil. Well, Carrie, let's start with you and have you kick it off. What are the emerging employment issues that you are dealing with and what you're hearing?
So it's really changing. It's changing every day. You know, everybody knows that the world just really got turned on its head about a week or 10 days ago. And so unfortunately, a lot of the questions that I started dealing with at the beginning that I think we're going to focus on here today are companies that are faced with the reality of either having to lay off employees or at least cut their hours, hopefully on a temporary basis. But, you know, it's the unknowns are out there right now, so we don't know how much of these actions are going to be more permanent. So today I'm going to kind of focus my discussion on best practices for what happens if you do need to lay people off. The federal government and the state of California obviously are trying their best to respond quickly and sort of dynamically as these issues are coming up. So I'm going to focus today on talking also about a couple issues dealing with the new federal law that is going to provide emergency paid sick leave and an expansion of the Family Medical Leave Act, and also issues dealing with what kind of notices have to be provided in the event of a mass layoff. So that's going to be the focus of the discussion, but I'll also just say, I mean, you can see things kind of shifting, and I find this to be a positive, that the immediate reaction from a lot of companies and contractors in particular, before sort of the orders started coming out identifying construction as an essential business, like I said, had to do with layoffs. Now we're starting to get into more the day-to-day questions dealing with how do you deal with people being in the workplace and having concerns about themselves becoming sick or their coworkers getting sick. So, you know, it's changing. So I kind of see as things start going forward that the questions are going to maybe move away a little bit from certain areas like layoffs and are going to focus more on how do we handle our employees in the workforce on a day-to-day basis, and, you know, what happens if they're not able to work due to sickness or things like their kids not being able to go to school. So do you want to, on my screen, I'm not seeing any change in the slides, so I don't know if the PowerPoint has started. Do you want me to start kind of getting into the brass tacks of my presentation?
Yes, please.
Carrie, this is Tim. We're on the layoff best required practices slide.
Okay, so I tell you what, for some reason my screen's not showing that, so I'll just tell you when I'm ready to advance to the next slide. How's that?
That would be great.
So
Thank you.
in terms of, all of you working in construction obviously have familiarity with how to lay people off, because clearly when jobs come to an end or you've got seasonal fluctuations in work, you're all familiar with sort of the layoff or termination process. So I'm really going to focus on, like I said, the real life issues that my clients have been dealing with in the very, recent short term since the shelter-in-place orders went into effect. So just a few things to kind of keep in mind in terms of when you're deciding whether or not employees need to be laid off. And the first one is interesting because there's a couple of terms that have been bandied about. One is layoff and the other one is furlough. And there's not really a very clear definition of what a furlough is. So the term furlough was used a lot back when the state of California and the federal government, at the beginning of the Great Recession, had to start kind of changing the schedules, mostly of public sector workers. So the word furlough generally refers to either a reduction in hours or a temporary layoff with a defined return date. And that becomes significant because when you're laying people off right now, unless you're very confident in a specific return date, you have to remember that when you lay somebody off, they are entitled to an immediate payment of all wages due and owing to them. So if you fail, literally I always tell people when you're laying somebody off, you need to send them out the door with their check in their hand. If someone resigns, you normally have, 72 hours to issue a final check. But in a layoff situation, the pay is due immediately. And if you fail to issue that final paycheck immediately, penalties start accruing. So 1 day's wages for every day that you have failed to issue a final check and all final pay, capping out at 30 days. So the other issue that comes up when we're talking about so-called furloughs or a more temporary layoff is what do you do if people have accrued paid time off or accrued vacation? And that's a real gray area, a real question that's coming up right now. And conservatively, if you're laying people off, even if you're telling them that it's temporary and you have every intention of bringing them back to work as soon as things open up and work picks up, that's probably going to be deemed a termination for purposes of triggering your obligation to pay out any accrued but unused vacation or paid time off. So, assuming you have the ability financially to pay out all that accrued leave, even if you're calling something a temporary layoff, again, unless you have a very specific defined date of return, short term in mind, you're best served to pay out that accrued leave. The other thing to keep in mind is, when you're letting people go, paid sick leave under our paid sick leave law, our California paid sick leave law does not have to be paid out. However, if you hire the employee back within a 1-year period of time, all of that accrued but unused paid sick leave gets restored. As always, in any normal layoff or termination, you are required to give notice to employees of their rights to unemployment benefits, and that's obviously particularly important right now. As we're going to talk about, the state of California has gotten pretty creative in terms of, when it's allowing, under what circumstances employment benefits are going to be available to employees. You want to make sure you give them that standard benefit. We're going to talk in a minute about, if you're instituting a so-called mass layoff, if you're a larger employer and you're laying off at least 50 employees, you may have a requirement to issue what's called a Warrant Act notice, and that's where we've had some very recent changes in the law handled through an executive order issued last week by Gavin Newsom. So I'll talk about that a little bit more later on. Obviously, you've got possible COBRA issues that come up if you're laying people off, or keep in mind, if you're reducing people's hours, you need to remember that that reduction in hours over time might have an impact on people's health insurance benefit rights. So just kind of keep that stuff in mind. Okay, how about we go to the next slide?
Carrie, at this time, I'm just going to remind the colleagues on the phone to please mute your phones if you have not already done so. Thank you.
Okay, thanks. So I'm going to focus the bulk of my time talking about two very recent changes in the law. One I just referred to that I'll address second, which are changes to the notice requirements in California if you're instituting a mass layoff. The other one is HR 6201, which was signed by the president last week on a federal level. This is the law that is going to impact everyone across the nation, creating paid sick leave and expanded family medical leave rights. So if we can switch to the next slide that's entitled HR 6201, Families First Coronavirus Act. So there was a lot of, information about this law in the news. The bill was initially passed by the House, and then when it went to the Senate, there were some fairly significant changes made to it. As I mentioned, it was signed by President Trump on March 18th, and it is set to go into effect 15 days after he signed it. So the SFCRA, as we're referring to it, is going into effect on April 2nd. So as I mentioned, the law has two primary, it has maybe 5 or 6 different provisions, but the two provisions that are the most important for employers deal with emergency paid sick leave and expanded family medical leave rights. There are some commonalities between those two aspects of the law, one being they both go into effect on April 2nd, the other being that currently the provisions for both of those types of leave will sunset on December 31st of 2020. The Department of Labor, which is the federal administrative agency that is going to be tasked with enforcing this new law, has indicated that there is going to be a temporary 30-day non-enforcement period after the law goes into effect. They're saying they're going to be focusing on trying to teach compliance during that time period, and they won't do enforcement procedures as long as an employer has made good faith effort to come into compliance with the law. So aside from those similarities and a couple others that I'll mention, these are two different paid leave entitlements. So it's important to understand what the differences are between the two and what each provision provides. So first of all, let's talk about the provisions of the new law that deal with providing emergency paid sick leave. So first of all, both of these laws, both the paid sick leave law and the family medical leave expansion, apply to employers, businesses who employ fewer than 500 employees. With the idea being that much larger employers should be providing, I guess as a policy decision, these types of benefits. So this mandate really applies to businesses that are mid-sized to smaller, so employing fewer than 500 employees. So that's the types of employers the law applies to. Now, in terms of employees who are working for these size companies, there is no length of service requirement. So, a lot of our laws only apply if you've worked for 30 days, et cetera. the emergency paid sick leave provisions of this law apply immediately to any employee, regardless of their length of employment. So the next thing that's important to understand is, effective April 2nd, 2020, what types of reasons will employees be allowed to take this emergency paid sick leave for? So there's basically 6 different reasons. 3 of them deal with an employee basically taking time off for their own issues. The other 3, well, really 2 of the other 3, apply to I'm taking time off to deal with someone else. So let's dig into that a little bit. So the first reason that employees are going to be able to take this emergency paid sick leave for is if they are subject to a COVID-19 quarantine or isolation order. So there's maybe some confusion over what that means. Also, the Department of Labor is supposed to be issuing regulations to flesh out some of the questions dealing with this new law within, again, 15 days of the law being enacted. So we may get some more clarification on these. My firm, we all read the idea that somebody can't work because they are subject to a quarantine or an isolation order to apply to the shelter-in-place orders that are going to be talked about a little bit, I think, by the other speakers. So that's one reason. The other one is if the employee has been, so again, the employee has to be unable to work for any of these reasons. Number 2 is they've been advised by a healthcare provider to self-quarantine. The third is they are starting to experience symptoms that they believe are COVID-19 symptoms, and they are seeking a diagnosis. So obviously you don't want people coming to work during that time period. So those are the 3 that deal with, I'm having to do something because I've been personally affected. The other reasons for taking emergency paid sick leave under this new law are I need to take time off to care for someone else because that person is subject to an isolation or a quarantine order, or because that person is experiencing symptoms and is in the process of getting diagnosed. The other reason is to care for a child, so a kid under the 18 or under, who has been impacted by school or basically paid daycare closures. So this is where there's a big overlap between the paid sick leave law and the expanded family medical leave that we're going to talk about. There's that reason for leave is common to both. And then the last reason is an employee is experiencing any other condition that's substantially similar to COVID-19 as designated by the Federal Department of Health and Human Services. So those are the reasons why an employee is going to be entitled to take time off under this law. So then the next question becomes, okay, well, how much time off are we talking about? And remember, this is paid sick leave. So how much paid sick leave am I going to be required to give people? So for full-time employees, this is basically a 2-week entitlement. So they are entitled to take up to 80 hours of paid sick time at their regular rate of pay. So as we're going to talk about, they'll get their regular rate of pay for up to 2 weeks for 80 hours. Full regular rate for the first 3 reasons for taking leave. So again, reasons related to your own, maybe being subject to an order or your own health issues. And then employees will be entitled to receive 2/3 of their regular rate of pay, again for full-time employees up to 80 hours, if they're needing to take time off for reasons 4, 5, and 6. So 4 and 5 being I'm taking time off to deal with somebody else. So for part-time employees, they are entitled to as much sick leave that would equate to the number of hours that they typically work in a 2-week period. So full-time, you're considered to typically work 40 hours a week. Part-time, it would be based on how many hours do you actually typically work during that time period. So importantly, even though the paid sick leave rates are tied to employees' regular rates of pay, there are caps on how much paid sick leave needs to be paid out. So again, the amount that has to be paid out, the maximum amount, depends on what the time off is being taken for. So if you take time off for reasons 1, 2, and 3 related to your own needs, the sick leave pay is capped at, depending on what your regular rate of pay is, capped at $511 per day, or a maximum aggregate amount of $5,110. If you are taking time off to care for somebody else, your sick leave pay is capped at $200 a day, or a $2,000 maximum aggregate. There is a tax credit available for the cost to the employer of providing this benefit. I am not a tax attorney, so I'm not going to try to get into the details of it, but I will tell you that the IRS has issued a really good kind of layperson explanation of what the tax credit is, and we anticipate that they're going to be issuing additional guidance fairly shortly. Couple things to keep in mind. This law does authorize the Secretary of Labor to issue regulations which would exempt small businesses with less than 50 employees from the paid sick leave requirement, only relating to the need to take time off for child care, not for all the other issues. If the providing this benefit would jeopardize the viability of the business as an ongoing concern. Now, who knows what that means? Who knows what's going to be required to meet that exemption? It just got dark in my office. I have to move around to turn the lights back on. Don't know quite yet how that exemption is going to work. That's an issue that's going to be addressed by the Secretary of Labor in regulations, which should be coming out fairly shortly. Couple other things to keep in mind. If this paid sick leave, again, as of right now, this paid sick leave is supposed to sunset at the end of the year. If for some reason it's extended, at least as of right now, if the leave hasn't been used, it does not carry over from year to year, and it is also not required to be paid out if unused upon the separation of employment. The law does provide that after an employee takes their first day of paid sick leave under the law, that the employer can require or put into place reasonable notice procedures of the need to take time off. A couple other very minor provisions of the law is that an employee cannot be required to find a replacement if they need to take this type of paid sick leave. And not surprisingly, it's unlawful to discriminate against employees who take this leave, and the penalties for doing so will be issued under the Federal Fair Labor Standards Act. So it's basically going to be the amount of time that the amount of pay the employee would have been entitled to, plus an equal liquidated damages amount, plus attorney's fees. So that's paid sick leave. So keep in mind, just as you're kind of trying to keep these types of leaves separate in your head, the paid sick leave requirement is fairly short, basically 2 weeks, and it's for various different types of reasons, all having to do with an inability to work due to COVID-19 issues. So if we could now flip to the next slide, we're going to talk about the other aspect of HR 6201, which is the expansion, the emergency expansion of family medical leave entitlements. So just to kind of back up a little bit, so in the normal world, the requirement to provide employees with unpaid family medical leave typically only applies to employers with 50 or more employees. And in order for an employee to qualify, they typically would have had to have worked for a company for 12 months and have worked 1,250 hours in the year before the need for leave arises. under this emergency expansion, again, similar to the paid sick leave requirements, these requirements that we're going to be talking about now apply to all employers with fewer than 500 employees. So as we're going to talk about, there is that same ability for the Secretary of Labor to exempt companies with 50 or less employees. Again, if it's they can show under whatever regulations come out that there's going to be a threat to the ongoing viability of their business if they have to provide this benefit. And the normal employee work history, so the working for 12 months and the 1,250 hours goes out the window. So unlike paid sick leave, which has no length of employment requirement, the family medical leave requirements only apply to employees who have worked for at least 30 days prior to the need for leave arising. So under this emergency family leave expansion, and again, this also sunsets at the end of the year, eligible employees can take up to 12 weeks of job protected leave. So for full-time employees, again, that's considered to be a 40-hour-a-week work week. And for part-time employees, it's the number of hours that they typically would have worked in a week period. And if somebody has fluctuating hours under both provisions, by the way, you look at the average number of hours they work typically have worked in the last 6 months on a weekly basis. So now this is where there was a pretty significant narrowing of the law when it went from the House to the Senate. So the reason for an employee to take this up to 12 weeks time off paid under this expansion is solely limited to circumstances where an employee can't work or telework because they have a child, again, 18 or younger, who's unable to attend school or go to otherwise paid care due to a closure caused by public health emergency due to COVID-19. So very limited basis upon which you can take this type of leave of absence. So remember, the child care issue is one reason that you can take paid sick leave. The expanded family medical leave is only available if a parent needs to take time off to care for their child because their child isn't in school because it's been closed due to COVID-19. So under this law, the first 10 days can be unpaid. However, an employee may elect to use paid sick leave. So for example, they could elect to use the 10 days that are permissible under the federal emergency paid sick leave provision that we just talked about. They also can elect to substitute paid vacation or other personal medical or sick leave that they might have available to them. So that's at their election. Then after that 10-day period, the paid leave component of it kicks in. So under this provision, employees are entitled to pay at 2/3 their regular rate of pay, but again, there's a cap, and under this provision, it's capped at $200 a day or $10,000 in the aggregate. And again, this provision also has a paid tax credit component to it. And again, as I mentioned, this provision also has an ability for the Secretary of Labor to issue regulations to exempt small businesses, so fewer than 50 employees, from the requirement to comply if they can show that it would jeopardize the ongoing viability of their business. And again, we're going to have to wait to see what the regulations look like. So just as with other, the other bases under which employees have been able to take family medical leave, this is job protected leave. So an employee is entitled, after they've taken this leave, to be restored to the same or comparable position that they were in when they went out on leave. However, this law does provide that for employees with less than 25 employees, You don't have to return the employee to their prior or comparable position at the end of them taking this leave if you can show that the position doesn't exist anymore due to changes in the employer's economic or operational conditions that affect employment and were caused by COVID-19. So, you know, if you go through a layoff and somebody's on leave, it's a COVID-19 layoff, and you have less than 25 employees, you don't have to restore them to their position. Big question as to what that does to employers with more than 25 employees. In order to meet this, to avoid the duty to restore someone to their position, you do have to show that you've made reasonable efforts to locate an equivalent position for them to go into, and for a 1-year period following either the end of the employee's need for leave or the expiration of the 12-week leave period, if any jobs become open, equivalent positions within a 1-year period, the employer is required to make reasonable efforts to contact that employee to bring them back to work. There is a requirement that employees who have advance notice or the need for this time off is foreseeable. So let's say, you know, I mean, the school closures happen really suddenly, but let's say an employee's been able to work because their spouse has been able to provide care for the children, but they know the spouse is going to be going back to work. If the need for this leave is foreseeable, notice has to be given as soon as is practicable. Okay, so that's the quick synopsis of those two laws. If we could now kind of change slides and change topics. So let's talk about circumstances where a company may be having to institute a mass layoff. So before COVID-19 ever came to be, both California and federal law had what are called the WARN Acts, the Worker Adjustment and Retraining Notice Acts, which basically require, the federal and the state laws are a little bit different, but that normally if an employer is going to be instituting a mass layoff, so for purposes of the California law, that means you're going to be laying off 50 or more employees over a 30-day period, and you're an employer with 75 or more employees, you are typically required to give at least 60 days advance notice of that upcoming layoff. And if you fail to give the 60 days notice, you could be required to pay back pay for that 60-day period plus a bunch of horrible penalties. So as COVID-19 came out and jobs started getting shut down, employers had to start implementing these big layoffs immediately without being able to provide any kind of notice. So people felt pretty comfortable under the federal WARN Act because it has always contained an exemption from the 60-day notice period for layoffs caused by a natural disaster. The California law doesn't have that exemption. It only has an exemption, an exception from the 60-day notice period for physical calamities, but nobody felt really comfortable that COVID-19 would be considered a physical calamity. That was mostly things like a hurricane or something like that. So there was a lot of confusion for a couple of days. Then Governor Newsom issued an executive order last week on St. Patrick's Day, actually, basically saying that going back to March 4th, 2020 and extending to the end of this COVID-19 emergency time period, the 60-day notice period for mass layoffs under the California WARN Act is suspended when the layoff is due to unanticipated COVID-19 business circumstances. Now, this is not a get out of jail free card because it still requires that notice be given as soon as is practicable. So if you know you have to institute a mass layoff starting Monday of next week, you don't have to give a 60-day notice, but you got to give notice in advance as soon as you possibly can. so the normal WARN Act requires that notice of layoffs or plant closures, et cetera, be given both to employees and to local government officials so that they can prepare for the influx of unemployed people. So that includes, you know, the Employment Development Department, the local Workforce Investment Board, and the 2 local elected officials on a county or city basis. So that notice still has to be given. I want to make sure people understand that. It's not that the notice went away completely. The notice that used to have to be given 60 days in advance now simply has to be given as soon as is practicable. The other thing is that, and again, there's all kinds of guidance out there on what the notice must contain. It has to let people, you know, give employees information about who to contact at the company if they have questions. They have to be notified if it's a layoff. Is it anticipated to be temporary or permanent? When do we anticipate the layoff happening? There is also very specific language and a link to a specific website that must be given to provide employees with notice of their right to file for unemployment insurance benefits. So make sure that you familiarize yourself with that specific information that has to be given. And that's a good segue into the last slide, if we could flip over to that. So just in terms of, you know, what kind of other resources are out there in addition to the federal, the new paid leave requirements that we just talked about. I just kind of quickly want to run through what the other types of resources and really state provided, not employer provided, wage replacement benefits due to various reasons that employees may not be able to work due to COVID-19. So first of all, keep in mind that if an employee themselves is unable to work because they are sick or possibly just simply waiting for a diagnosis related to COVID-19, we still have our state disability insurance benefits. And again, the state is they're being more flexible about eligibility for benefits, both SDI and unemployment. And whereas there is typically a 7-day waiting period to obtain state disability insurance benefits, that 7-day waiting period has been waived when somebody can't work due to physical illness caused by COVID-19. In terms of an employee who's unable to work because they're caring for someone else, for example, who has COVID-19, our state paid family leave benefits, which is again a wage replacement benefit provided by the state of California, employees can still apply for that benefit, and it provides them up to 6 weeks wage replacement benefits, and that benefit is actually going to expand to 8 weeks in July. So if this is still going on, that would be an expanded benefit that would be available. Now, in terms of unemployment insurance benefits, again, the state is getting creative and they're really easing up on the typical unemployment insurance eligibility requirements. So first of all, again, if somebody has suffered a loss in employment, they normally have a 7-day waiting period before their unemployment benefits kick in. That 7-day waiting period has been waived. And then also employees who have suffered a reduction in hours, so they're still working, but not their full hours, so they're suffering a wage loss, they are also eligible to apply for unemployment insurance benefits. And the EDD, normally if you're unemployed and you're collecting benefits, you're required to be showing that you're actively looking for other work. But EDD has said, and actually an executive order has been issued on these topics as well, if an employee is on a temporary layoff, they will not have to show that they are actively seeking work each week if they're expected to return to work in a fairly short period of time. So just keep in mind there's a link on the slide to a fantastic set of frequently asked questions that I think is actually very helpful for employees. So if you have employees who are impacted by COVID-19, just keep in mind these state benefits that are available, wage replacement benefits through the state of California, and you might want to think about providing them access to those resources as well. So with that, I will end my portion of the presentation. Happy to take questions at the end, but I'll turn it over for the discussion about contract issues dealing with COVID-19.